In our last lesson, we talked about the many new concepts covered in Article 29 of the Civil Code. We talked about the basics of criminal prosecution, the degrees of proof, or quanta of evidence, and where each of them applies. We also talked about the general rule that every person criminally liable is also civilly liable. The exception to this rule is when the accused is acquitted on the ground of reasonable doubt. Then the offended party may still hold the accused liable in a civil case for damages. But this time, the quantum of proof required is mere preponderance of evidence. The exception to this exception is found under Rule 111 of the Rules of Court. The civil liability of the accused will be completely extinguished when there is a finding that the act or commission from which the civil liability might arise does not actually exist. By the end of this lesson, you should be able to, number 1, enumerate the requisites for the application of Article 30 of the Civil Code. 2, explain the effects of the reservation of a separate civil action on the prosecution of the criminal case. 3, identify the effects of the death of the accused upon his or her criminal and civil liability. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 30 of the Civil Code provides that when a separate civil action is brought to demand civil liability arising from a criminal offense and no criminal proceedings are instituted during the pendency of the civil case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Gaya ng aking nabanggit kapatid, this is a very short and simple provision. Walang mahirap unawain dito, kaya simulan na natin. Article 30 of the Civil Code teaches us that a crime happened. Rather than bring the matter to the city or provincial prosecutor, the offended party filed the separate civil action. Gaya ng ating natutunan sa last lesson, malinaw na sa lahat ng civil case, the quantum of proof required is mere preponderance of evidence. That is level 2 in our enumeration of the degrees of proof. Article 30 of the Civil Code also teaches us that during the pendency of the separate civil action, no criminal charge was filed. The practical effect is that the civil case will proceed. The offended party will have the chance to prove the civil liability of the defendant, but in no case can the defendant be imprisoned. Justice Paras makes a very simple illustration of Article 30 of the Civil Code. Halimbawa daw ay may dalawang magkaibigan na si A at si B. Dahil sa kahirapan na maaaring dala na rin ng pandemya, ninakaw ni B ang relo ni A. A obviously has the option to file a criminal case of theft against B. Pwedeng-pwede niyang ipakulong si B dahil sa pagnanakaw, and in the same process, mababawi niya ang kanyang relo at anumang danyos or damages. A has another option, and that is one provided under Article 30 of the Civil Code. A can file a civil action to recover his personal property, his watch plus damages, and whatever he has spent in legal fees. Kung hindi magsasampa ng reklamo si A laban kay B, hindi makakapag-file ng criminal case ang ating prosecutor. Wala kasing testigo na nagnakaw nga ng relo si B. Kung hindi magsasalita si A, hindi malalaman ng husgado na kanya nga ang relo at ang relong ito ay nawala sa kanya. If A takes the option under Article 30 and no criminal case is filed against B, then the quantum of proof required is mere preponderance of evidence. Proof beyond reasonable doubt will not apply because this is a separate civil action and not a criminal case. Kung ikaw kapatid ay nagmamadali at pinapanood mo lang ito para ma-review sa iyong exam o recitation, then you can stop here. But I want to continue to share with you the rules on the reservation of a separate civil action and the effects of the death of the accused, plus a few cases to drive home the point. The rest of the discussion here you will encounter on your second and third year when you go through torts and damages and criminal procedure. Katulad ng aking nabanggit sa ating nakaraang lesson, Article 100 of the Revised Penal Code provides that every person criminally liable is also civilly liable. The basis for this rule is the principle that every crime causes damage to two persons. The first is the state. Kasalanan sa ating lipunang ginagalawan ang panggagahasa. The second person is the private offended party, or in this case, the rape victim. The crime of rape leaves an indelible mark upon the victim. Ang pagbabayad ng danyos o damages is somehow a way to make the person whole again. With that being said, let us now go to the first and probably most important rule. You have to remember this, kapatid, because it is the only reason why we have the rest of the rules on separate civil actions arising from crimes. The last sentence of Section 3 of Rule 111 of the Rules of Court teaches us that in no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. Sa provision na ito, kapatid, makikita natin na bawal daw ayon sa ating batas ang makarecover ng damages twice or two times for the same act or omission charged in the criminal action. Sa aking halimbawa kanina kung saan ninakaw ni B ang relo ni A at ang value ng relo ay kunwari nasa 150,000 pesos. Ang mababawi lang ni A sa kanyang civil action ay ang relo o ang 150,000 pesos. Pagkatapos noon ay hindi na pwedeng magsampa ng ibang kaso si A laban kay B para makabawi ulit siya ng 150,000 pesos. Hindi niya pwedeng pagkakitaan ang krimen na ginawa laban sa kanya. The prohibition against double recovery or recovering twice the damages based on the same act or omission is based on the principle of unjust enrichment under Article 22 of the Civil Code. There is a separate lesson for this, and in case you missed it, I'll be leaving a link in the description down below. Halimbawa, kapatid, noong natuklasan ni A na ninakawan siya ni B ng relo, saka pa lang niya nalaman na si B rin pala ang nagnakaw ng charger niya ng Samsung Galaxy S21. Can A now recover the value of the charger from B? Will the prohibition on double recovery apply? The answer, kapatid, is no. Section 3 of Rule 111 of the Rules of Court teaches us that the law prohibits double recovery for the same act or omission. The act of stealing a watch worth 150,000 pesos is different from the act of stealing a cell phone charger. Next rule, kapatid, is Section 1 of Rule 111 of the Rules of Court, which tells us that when a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with the criminal action. This rule tells us that by default, every person charged with a crime is automatically charged with the civil aspect of the crime. The basis of this rule is Article 100 of the Revised Penal Code. Ang civil action ng isang krimen ay kung ano man ang mababawing danyos ng biktima batay sa naging atraso sa kanya ng akusado. Sa kasong pagnanakaw, yan ay ang halaga ng ninakaw. Sa kasong homicide, danyos para sa pamilya ng namatay, at sa krimen na rape ay damages sana to somehow make the victim whole again. The law automatically combines the criminal and civil aspect of the crime to save time, money, and energy on the litigation. Meaning, sa isang kaso lang papatunayan na ang akusado nga ang nagnakaw, kung ano ang ninakaw niya at kung magkano ito, para alam na natin kung magkano ang kanyang dapat panagutan. Kung sa isang kaso lang ang paglilitis, isang beses lang papasadahan ang mga isyu na aking nabanggit. Hindi na kailangang kumuha pa ng ibang abogado para dito. Hindi na rin kailangang makinig ulit ni judge sa mga karimari-marim na kwento ng ating mga testigo. The same provision, Section 1 of Rule 111, also provides for us 3 exceptions to the general rule of the automatic institution of the civil aspect of the case. These are 1. When the offended party waives the civil aspect of the case. 2. When the offended party reserves the right to institute a separate civil action. 3. When the civil action is instituted prior to the criminal action. Now, let's discuss these exceptions. Una, kapatid, would be a waiver of the civil aspect. Ang waiver ay isang malayang pagtalikod sa isang karapatan. Maaaring pinapalampas o pinapatawad na ng isang tao ang anumang atraso sa kanya. For a waiver to be valid, the person must actually have the right that he or she renounces and that he or she must have the capacity to make the renunciation. The renunciation must be made in clear and unequivocal terms, and that this waiver must not be contrary to law, public order, public policy, morals, or good customs. There is a separate discussion on waivers, and in case hindi mo pa napapanood, kapatid, there will be a link to that in the description down below. The second exception, kapatid, is when the party reserves the right to institute a separate civil action. When a party makes a reservation to institute a separate civil action, the party in effect is asking for the permission of the court to file another case, a different case, based on the civil aspect of the crime. In practical terms, kapatid, maaaring humingi ng reservation to file a separate civil action dahil walang tiwala ang party na mapoprotektahan ng prosecutor ang kabuuan ng kanyang karapatan dahil karamihan sa kanila ay overworked, underpaid, at hindi 100% ang focus sa bawat kaso. Meron ding humihingi ng reservation dahil kulang ang ebidensya on hand. Madalas humihingi ng reservation batay sa diskarte ng abogadong unang nilapitan ng offended party at malabong makapasok ito bilang private prosecutor sa isang kaso. How do you make a reservation, kapatid? A reservation for the right to file a separate civil action in effect is asking for permission from the court na kung pwede sa ibang case na natin ito pag-usapan at promise hindi po ito kasayangan ng inyong oras. A reservation has to be made by motion. More on that when we discuss criminal procedure. When do you make a reservation, kapatid? Section 1 of Rule 111 of the Rules of Court tells us that the reservation has to be made 1. Before the prosecution starts to present its evidence. 2. Under the circumstances affording the offended party a reasonable opportunity to make such reservation. Again, nothing difficult here, kapatid. Number 1 tells us that we can make the reservation at any time before the prosecution starts. Number 2 tells us that we can make the reservation at any time so long as the offended party has been given the chance. Usually, the reservation is made during pre-trial. Pre-trial, kapatid, is the stage of the criminal prosecution where the prosecution and the defense actually sit down and try to work out a few things for the speedy and orderly conduct of the trial. Dito pinag-uusapan ng plea bargaining o ang pagpiplead na lang ng accused to a lesser offense in relation to the crime charged. Dito na rin pinag-uusapan ang stipulation of facts, the identity of the accused, the victim, and other preliminary matters. Pre-trial, kapatid, is a good chance to make the reservation. Kadugtong ng rule ng reservation by the offended party ay isa pang rule na kailangan mo ring matandaan, kapatid. In the case of Sarmiento versus Court of Appeals, the Supreme Court ruled that the reservation of the right to file a separate civil action may be express or implied. It is expressed when the offended party makes a motion to reserve the right to file a separate civil action. It is implied when, number 1, when the court finds that the remedy of the offended party is civil, not criminal. 2, when the court fails to make a ruling on the civil aspect of the case. In the same case, the Supreme Court, speaking through Justice Ostrea Martinez, teaches us that the appearance of the offended party in the criminal case through a private prosecutor may not per se be considered either as an implied election to have his claim for damages determined in said proceedings or a waiver of his right to have it determined separately. He must actually or actively intervene in the criminal proceedings as to leave no doubt with respect to his intention to press a claim for damages in the same action. The primary effect of the reservation for a separate civil action is that the prescriptive period of the civil action reserved is tolled. As you will recall from previous lessons, the law puts an expiration date on the right to come to court. Some crimes prescribe in 20 years from the time they are committed. Others expire within 4 years from the crime is committed or from the discovery of the crime. The prescriptive period or this expiration period depends on the gravity of the offense and the imposable penalty. Pagdating sa reservation, kapatid, the practical effect is that the prescriptive period stops. Kumbaga sa computer shop ay stop time muna tayo, kapatid. Hindi muna aandar ang prescriptive period ng civil aspect ng crime until the final judgment in the criminal case. There are three kinds of cases where the reservation of the separate civil action is not allowed. They are 1. Cases falling under Batas Pambansa bilang 22 or the Bouncing Checks Law. 2. Cases falling under the jurisdiction of the Sandigan Bayan. 3. Tax cases as provided under Republic Act No. 9262. Batas Pambansa bilang 22 or the Bouncing Checks Law is going to be your primary illustration when you get to law school. It's the perfect example because it happens a lot and it is very near to our personal experience. A bounce check is a check that is dishonored by the bank. Hindi tinanggap dahil walang laman ng account o kulang ang laman ng account. BP 22 punishes the act of a person who writes and issues a check knowing that at the time of issuance, the balance on the account is not enough to cover the check and that this check was subsequently dishonored by the bank or that the check would have been dishonored had it not been stopped by the writer and issuer of the check. Sa isang kasong isinulat ni dating Chief Justice Maria Lourdes Sereno, ang BP 22 daw ay walang reservation ng separate civil action. Again, kapatid, as we have discussed earlier, the rule is automatic institution and reservation is the exception. Wala daw reservation dahil ang kasong BP 22 ay common na kaso. Laging merong nagrereklamo sa ilalim ng BP 22. Dahil nga marami ang kaso, pinagbawal ang reservation ng separate civil action para hindi maubos ang oras ng ating mga korte alang-alang sa mga kaso under BP 22. Kadalasan kasing ginagamit ang mga Metropolitan Trial Court at Municipal Trial Court bilang mga collection agency. Tinatakot ang mga may utang na kakasuhan sila ng BP 22. Sa takot ng mga umuutang ay sila rin naman ay nagbabayad. Hetong mga nagrereklamo ay kadalasan daw, sabi ng ating dating Chief Justice, ay hindi man lang sinasabihan ang mga korte na nagbayad na po ang akusado, okay na po, at iniaatras na po namin ang aming mga reklamo. Presidential Decree 1606 is the law penned by former President Marcos in his capacity as the legislative branch of government. It is the law that created the Sandigan Bayan. It is a special court that sits on the same level as the Court of Appeals. The Sandigan Bayan has exclusive jurisdiction over violations of the Anti-Graft and Corrupt Practices Act, crimes committed by public officers and employees, including those employed in government-owned or controlled corporations, under Title 7 of the Revised Penal Code or the part of the RPC that defines crimes committed by public officers and such other crimes committed by public officers in relation to their office. Walang reservation kapag ang kaso ay pasok sa jurisdiction ng Sandigan Bayan. Dahil una, walang private offended party. Kapag ang mga opisyales ng PhilHealth ay nagnakaw mula sa kanilang pondo, hindi ikaw at ako ang nanakawan dito, kapatid. Ang kaban ng bayan ang nilimas. It is an offense primarily against the state, against the people of the Philippines. There is no private offended party who can make the reservation. Sa parehong paraan in tax cases, wala ring reservation dito. This is because when a person evades taxes or does not file his or her taxes correctly, the offended party here is not you and me, kapatid. Ang tax evasion ay crime hindi laban sa atin, kundi sa ating lipunan, sa ating estado. Kung walang private offended party, wala ring reservation na pwedeng mangyari. In all these three cases, those under BP 22, those under the Sandigan Bayan, and tax cases, the rule is automatic institution. The civil liability arising from the crime charged is automatically deemed instituted when the criminal case is filed. Paano naman po kung ang akusado, the accused himself, who wants to file a civil case against the private offended party? Paano kung sabihin ni B na hindi siya nagnakaw ng relo ni A at yung relo na yan ay isinanla talaga ni A dahil sa kanyang pagkakautang kay B? Can the accused make a reservation to file a separate civil action? The answer, kapatid, is no. The accused cannot make a reservation to file a separate civil action. By express provision of Section 1 of Rule 111 of the Rules of Court, no counterclaim, cross-claim, or third-party complaint may be filed by the accused in the criminal case. But any cause of action which could have been the subject thereof may be litigated in a separate civil action. In one case, the Supreme Court discussed the reason behind this rule. The prosecution of the accused is not the proper forum to discuss his or her claims against the private offended party. Magkakalabo-labo na kung sakaling papayagan ng ating mga husgado na litisin ng mga kautangan ni A kay B. Remember, kapatid, sa isang criminal prosecution, the case is between the accused and the people of the Philippines. The proper remedy, the Supreme Court says, is for the accused to file a separate civil action against the private offended party. In this manner, the private offended party na ngayon ay defendant na laban sa ating akusado ay magkakaroon ng pagkakataon na ilatag ang lahat ng mga defenses na available sa kanya. Hindi niya ito magagawa ng maayos kung ito ay ipapaloob lamang sa criminal case sa isang akusado. Two other concepts I would like to discuss with you, kapatid, are the suspension of the separate civil action and the consolidation of the criminal and civil actions. However, it will not be very practical to discuss these concepts without first understanding independent civil actions. Kaya sa susunod na lesson na natin ito pag-uusapan, kapatid. If you are looking forward to the next lesson on Intro to Persons, please let me know by typing following in the comments down below. For now, I would like to talk about the effect of the death of the accused on the civil action. 25% ito ng aming midterms noon sa person at sadly, kapatid, mali ako. Simple lang kasi ang sagot ko sa tanong na ito, kaya laking gulat ko bakit 25% ito ng aming exam. Ayokong matulad ka sa akin, kapatid, at makakuha ka lang ng 6 points out of 25 dahil matipid ang sagot. Kung nakuha ko ang tanong na ito ay malamang hindi ganun kababa ang grade ko sa midterms at hindi rin ganun kalaki ang dapat kong habulin sa finals. Favorite ang tanong na ito sa exams, kaya kapatid, please listen carefully. There are 4 periods or stages in the prosecution of the criminal case when the accused might die. They are: number 1, anytime before arraignment; 2, after arraignment and during the pendency of the criminal action; 3, during appeal; 4, after judgment. Section 4 of Rule 111 of the Rules of Court tells us that if the accused dies at any time before arraignment or that part of the prosecution where the accused must stand before the judge and the clerk of court will read to him or her the specific facts and circumstances that amount to a crime, and the accused is asked whether he or she is guilty or not guilty, then the criminal case shall be dismissed. Absuelto ang ating akusado. Heto, kapatid, ang dahilan kung bakit maraming mga hostage taker at serial killer sa ating mga pinapanood ang nagpapakamatay na lang bago sila mahuli ng FBI o ng ating kapulisan. When a person dies, all of his or her criminal liability is extinguished. The case is different upon the civil aspect of his or her crime. Remember, kapatid, sa kanyang pagkakamatay ang ating akusado ay absuelto sa kanyang krimen laban sa people of the Philippines. Pero pagdating sa danyos, ang ating biktima or the private offended party can still file a case against the estate of the deceased o kung anumang naiwan ng ating akusado. Pera, bahay, lupa, kotse o alahas. Doon kukunin ang damages. When the accused dies on the second stage of our timeline or after arraignment but during the pendency of the criminal action, Article 89 of the Revised Penal Code tells us that criminal liability is totally extinguished by the death of the accused. Hindi kasi natin maaaring ipakulong ang mga labi ng akusado. Hindi hustisya ang makakamit natin dito, kundi sakit, kapatid. Section 4 of Rule 111 of the Rules of Court gives us the general rule. When the accused dies on the second stage or after arraignment but during the pendency of the criminal action, then the civil liability of the accused is extinguished. Take note, kapatid, absuelto ang ating akusado sa kanyang sala laban sa people of the Philippines at sa private offended party o ang naging biktima ng krimen. Sa unang tingin, kapatid, ay parang unfair. Nagkaroon lang ng arraignment ay lusot na ang ating akusado sa civil aspect, sa damages or for the amount of money designed by the law to make the victim somewhat whole again. You see kapatid, there are different sources of obligations. When someone borrows money from us, the borrower is burdened with the obligation to pay. The basis of that obligation to pay is a contract, specifically a contract of loan. When we make money from selling things online or for giving someone else our time, energy, and attention, we are paid for our effort. The basis of that obligation to pay is the contract of sale or the contract of service or contract of employment. From the proceeds of our sales, of our salaries, we earn income. From our income, we have to give back our share so that the government will keep our roads flat and clear of potholes so our government can buy vaccines for people who may not be able to afford it. That money comes from the taxes we pay. We pay taxes whether we like it or not. The source of this obligation to pay taxes is the law. Medyo overwhelming kapatid, but don't worry, we will discuss sources of obligations in our next lesson. For now, please remember that there are various sources of obligations and one of them is a crime or delict. When a person commits a crime, he or she is in effect burdened with the need to make payment in the form of damages. Under Section 4 of Rule 111 of the Rules of Court, the civil liability of the accused is extinguished when the accused dies after arraignment and during the pendency of the criminal action. Meaning, the obligation to pay for damages because of the crime is also extinguished. The exceptions are, number 1, independent civil actions under Articles 32, 33, 34, 35, and 2176 may be continued against the estate or the legal representative of the accused after substitution. 2, if the civil aspect of the case has been reserved and later on filed by the private offended party, then the civil action will also proceed after the substitution of the parties. The first class of exception falls under independent civil actions. Don't worry about this kapatid because we will discuss these in our next lessons. Ang ikalawang exception naman ay ating natalakay kanina at ito rin ang isang malaking advantage ng reservation ng right to file a separate civil action. The third stage of the criminal prosecution is the appeal. Ang appeal kapatid ay walang kinalaman sa iyong kagandahan o kagwapuhan. Wala itong kinalaman sa malinis mong kutis na mapupuno ng pimple sa pagpasok mo sa law school. Appeal kapatid is a remedy where the decision of a lower court or a quasi-judicial body is taken up to the next higher court. When a party makes an appeal, he or she is in effect asking for the supervisor of the lower court to check the actions of the lower court, and he raises all the available arguments that might change the mind of the higher court. As applied in criminal actions, the accused has the right to file an appeal. Ang kanyang kalayaan ang nakataya dito, kaya pwedeng-pwede siyang lumapit sa next higher court at umapila at baka sakaling may mali si judge na pwede nilang itama. Kung sakaling sinabi ng trial court na laya ang ating akusado, hindi na pwedeng mag-appeal ang prosecutor. Nakasaad sa ating saligang batas na bawal ang double jeopardy. Heto kapatid ang muling paglilitis sa isang krimen na minsan nang kinaharap ng ating akusado. Kung wala ang rule na ito, ibig sabihin ay pwedeng maging unlimited ang pagdurusa ng isang taong akusado. Kung paulit-ulit ang trauma sa kanya ng trial for the same act, for the same offense, and probably using the same witnesses. Dahil sa prohibition against double jeopardy, kung sinabi ng trial court na acquittal, then the matter is now closed. The accused cannot be tried again for the same offense. End of conversation. When the court orders the acquittal of the accused but orders him to pay damages, then the accused can still go to the next higher court and appeal his case. Lalo na kung ang penalty ay excessive o hindi naman ganun kalaki ang kanyang ninakaw. When the court orders the acquittal of the accused but does not order him to pay damages, then the private offended party can also go to the next higher court and appeal the payment of damages. Lalo na kung ito ay kulang o in other cases, walang damages na ipinababayad sa ating akusado. When the accused dies during the appeal, then we follow the general rule. The criminal liability of the accused is extinguished based on Article 89 of the Revised Penal Code. The civil liability of the accused, on the other hand, is also totally extinguished. However, at dito na nga ako nagkamali sa aming midterms, kapatid, only the civil liability of the accused arising from the crime or delict is extinguished. If the private offended party can anchor his or her claim for damages upon another source of obligation, such as a contract or quasi-delict or some other provision of the law, then the civil action based on another source of obligation will prosper. Finally, we have the last stage or after judgment. Kung namatay ang ating akusado after judgment, then we have the following scenarios. Number 1, the accused is convicted and he has to pay. 2, the accused is convicted but he has no obligation to pay. 3, the accused is acquitted but he has to pay. 4, the accused is acquitted but he has no obligation to pay. In all of these 4 scenarios, the civil liability of the accused is not extinguished. Pwedeng managot ang ating akusado at ang dapat magbayad dito ay ang kanyang estate mula sa kung anumang naiwan niyang ari-arian gaya ng bahay, lupa, kotse o alahas. To summarize tonight's lesson, number 1, Article 30 of the Civil Code applies when a private offended party opts to file a civil action instead of a criminal case. The quantum of proof required is mere preponderance of evidence. 2, a reservation to file a separate civil action may be made at any time before the prosecution presents its evidence or when the offended party has the reasonable opportunity to do so. 3, the reservation of the right to file a separate civil action may be made expressly or impliedly. The practical effect is that it stops the running of the prescriptive period. Number 4, the death of the accused at any stage of the prosecution will extinguish criminal liability. The civil liability of the accused based on the crime or delict may or may not persist depending on the stage of the prosecution. I think we can stop here, kapatid. Our next lesson will be on Article 31 of the Civil Code and independent civil actions. We're also going to take a look at sources of obligations. All of these concepts, kapatid, you will encounter not in persons but in torts and damages, obligations and contracts, and criminal procedure. Pasensya na, kapatid, kung muling napahaba ang ating discussion. Iba pa rin kasi kung naiintindihan din natin ang mga konsepto at rules na sumasanga mula sa iisang provision ng batas. If you find this format of the lessons working for you, please let me know in the comments down below. Finally, there is a quiz that you can take to measure how much of the lesson you actually absorbed. Please type your scores in the comments. Okay lang sa akin, kapatid, kung mababa ang score mo. Gawin nating inspiration yan. Okay lang na dito ka na mahirapan at bumagsak kesa sa actual quiz, recitation, or exam sa inyong klase. If you would like us to continue with the next lesson, please type yes in the comments down below. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.